Thank you. If I may continue with the handwriting evidence, and we were at page 2281 in the appellant's case, looking at paragraph 19, and the submission on the safety of the conviction in relation to this evidence is that it is fundamentally flawed, albeit because of the specimen sample being fundamentally flawed, albeit there was no application to exclude the evidence that is accepted. There was an application made at the close of the prosecution case relying on the flawed nature of this evidence. However, that didn't succeed, and in our submission it wasn't then remedied by the summing up, in that the summing up provided no warning to the jury of the flaw in the specimen sample and what weight to give that evidence. And the admissibility and warnings that can be given perhaps is referred to in the authority of Robinson. If we can just refer to that case very briefly. It starts at page 2782 in the authorities bundle. And the head note, it's a Court of Appeal case, the head note sets out an outline of the facts, and it related to, in fact, two trials. The first trial, during the first trial, the deceased widow heard the appellant speaking and then considered that that was the same voice as the person who'd telephoned her on the night of the deceased's disappearance, attempting to carry out blackmail. And she then gave a statement to that effect, and in the first trial, that statement was ruled inadmissible after legal argument. There then was a retrial, and the judge was asked to rule on the same statement and ruled it admissible. And in terms of the principle that we rely upon when looking at...
So this wasn't expert evidence?
Not expert evidence, no.
It was just somebody's claiming to recognise a voice?
Yes, yes.
Because you can have voice recognition experts.
You can, yeah.
It's probably
yes.
have had.
Yes, absolutely. I've spent many weeks with voice recognition experts, but not sadly in this case. And page 2787 is really the proposition that we direct the board's attention to. And this is where, on the appeal, there was the consideration, starting at paragraph 18, of section 78 on a judge's discretion to exclude evidence on the ground of prejudicial effect outweighing probative value. And then looking at the basic test here of admissibility. And at paragraph 19, what's the basic test? It doesn't appear that a test was formulated for either of the trial judges who appears for the Crown before us. But the Crown suggested, and the Court of Appeal found this helpful, is the evidence such that no reasonable jury properly directed as to its defects could place any weight upon it? So looking one step before discretion and prejudice, looking at admissibility, and then put the other way around, if the evidence is such that a jury properly warned could place some weight on it, it should be admitted. It's our view that this basic threshold of admissibility is a low threshold. Applying that proposition to this case, if it were that the threshold of admissibility being a low threshold, therefore it was right for Mr Major's evidence to be admitted, our submission is that a warning or a direction to the jury as to caution and weight to give that evidence should have been included in the summing up, and it wasn't. And so the balancing of a low threshold in our submission is a careful balancing whereby there's an expectation of a direction from the judge in summing up as to weight. So assistance in our submission needs to be given to the jury. And in this summing up by the learned judge, and we don't criticise her, it's a very long summing up, and she obviously did her best to give all the evidence to the jury, but in doing so, it was a very long recital of what the evidence was. And I think your Lordship raised at the opening of this appeal, perhaps the word narrative. It's a long recital with actually no assistance, which might be not a source of necessarily of complaint. We're not necessarily looking at terms of perfection, but where it is on a key aspect of evidence that formulates effectively the only expert evidence in the case, the handwriting evidence, that had to be treated with caution and with care and with direction to the jury. And the generic directions to the jury that it's a matter for them whether they accept or reject an expert are insufficient. And those generic directions were considered sufficient by the Court of Appeal. In our submission, the Court of Appeal, with respect, fell into error there with this particular case and with these particular issues which were accepted in terms of the obtaining of the sample. Returning to the written case, and if I can just answer some of the questions from before lunch, hopefully, and put a little bit more colour on what happened here. Your Ladyship raised quite properly that one perhaps common sense approach as to why somebody providing a specimen sample would not have the disputed sample in front of them so that they cannot doctor their own writing to be different. And I responded in submissions before lunch that what's actually interesting here and perhaps works in the appellant's favour is that there were pictorial similarities between the two. So it's not a case where if he was trying to manipulate, there would have been some evidence of that, or perhaps an entirely different looking document. And in fact, we submit a little bit further that it could have been that Mr Edwards felt some pressure to make his writing look like the disputed document. And why we say this is, and this again is looking at how the specimen came about, is looking at the evidence of DI FIPS. And this will mean we need to go to the record, and it's page 6. Perhaps we start at page 606, please, in the electronic bundle. Just to put in context, so page 606 in the electronic bundle, this is the cross-examination of DI FIPS. And I'm starting here because it might answer some questions on the notebook as well at the same time. And at number 18, the question, did you say to the magistrate, at the scene, I found a notebook on the dresser in a bedroom which adjoined the bathroom in which the deceased was located? Yes, ma'am. The notebook was closed? Yes, ma'am. That is an additional piece of evidence to support the earlier submissions on the change of account of this officer, in that also to the preliminary inquiry to the magistrate, he made no mention of the notebook having been pointed out to him by Sergeant Brown. So that's at page 606, and also that the notebook was closed rather than open in order to be seen. And then we can move forward to page 635, please. At page 635, Superintendent Phipps is questioned about number 11. He's questioned about a dream that the mother of the deceased, it's put in, the mother of the deceased had told him that she'd had a dream, that the mother had had a dream that she was going to lose one of her daughters, and also that the mother had told the officer this at the scene. And so he's questioned on this, and then he says he doesn't remember. And then the questioning at number 18 is, having read that in the note, did you consider it important for you to interview Mrs Maud Harris about the dream? What dream, what dream? Let's go with the note. You're playing a game. The note says, and the note refers to, she writes that her mother was right with her dream, and also the deceased writes that she had a vision. And in the submission of the defence and the appellant, this was important evidence, potentially, an important part of the investigation, which Mr Phipps did not follow up. He did not consider the content of the note. The vision at page 639, where he's questioned again at page 639 at the top of the page, counsel asked him, did you make any effort to find out about the dream, any dream that her mother had? And he answered, I made no effort to find out anything about vision that is mentioned in here, because I don't even know what is that. You made no effort to ask dream, vision, and then there's quite a lot of argument. But he doesn't pursue it.
Where is this taking us?
Yes, I'm trying to perhaps weave the 2 points together.
I see.
I'm taking the content of the note is important. So can I ask that that's borne in mind and parked now that you see the reference to it? It doesn't appear in the summing up, is partly where it's taking us. And in terms of motive, the jury were considering, undoubtedly, as a young woman, suddenly she goes and shoots herself in the bathroom. And there was some evidence here, which was not followed through, of a potential motive as to why, relating to a spiritual visitation upon the mother and upon the deceased, and also as to where...
Is the suggestion that the police should have investigated whether, with the mother, whether the deceased was suggestible and that she was acting to protect her sister? Is it something like that?
My Lord, not exactly in terms of suggestible. We submit that the mother should have been asked, it should be followed up with the mother as to more detail about the dream. She was asked when she was questioned in court how her daughter had reacted when she said she told her daughter.
And she cried. And
she cried, yes, absolutely, my Lord. And obviously, in terms of the content of the note, it's of importance if the defendant, if the appellant could not have known of the information about the dream and the vision, and yet it's within the content of the note.
We just simply don't know.
We don't know.
There was no evidence that the deceased told the appellant about the dream. But
absolutely.
There would have been an opportunity to do so, clearly.
Yes.
Because they were together before she died.
Yes, absolutely. But there's no evidence that this was discussed, and in fact he did give evidence as to what was discussed, and it was about their children and the education of the children. And also we have the time that the two were together, which was quite a fairly shortish time. But it didn't appear in the summing up. And Mr Phipps is asked about the note. He then is asked about how he took the sample. And if we just go over the page, please, to page 648. This is where he's answered at the top of the page, where he says at number 2, he says, okay, I told him that in keeping with the investigation, it's advisable that he provided us with a specimen of his handwriting. I told him that in obtaining the specimen, I would want him to write the words that are written in the notebook that was found open. And then at number 20, on the same page, 19 and 20, I showed him the notebook and asked him to write the words that are reflected on the paragraph page, the specimen of the handwriting that I would require. Now, the note is written in one line, yes, ma'am, and numbered, yes. And then over the page at 649, about halfway down the page, our submission is that the methodology in taking the specimen, which is done by this officer, is one in itself which is flawed because he had no expertise on how the sample should be taken. And secondly, there's an evidential basis that it's flawed in that he's very vague as to what direction he gave him. And this submission is to support the suggestion, perhaps, that the appellant might even have thought that he had to make his handwriting look similar to the note, and hence the pictorial similarity. It's just very vague and very, very poor. And obviously this is
Where was this done? Where was this taken, this sample?
In the police station. The local police station.
And had he already been charged with the offence?
No, he was charged in November, and the sample...
He knew that he was there on suspicion of having murdered the deceased.
Well, it was put to him, the evidence was, I told him in keeping with the investigation, it's advisable that he provided us with a specimen of his handwriting. That was the evidence at page 648. So rather than, he wasn't cautioned.
No, but he would know that,
yes,
at best for him, it was something to exclude him from suspicion.
Yes, absolutely. He said he gave evidence. He was shown the note on the 6th of September for the first time at the police station and was asked to provide a sample in 2003. But then at 649, when the officers asked, so it starts about number 8. So he just went ahead and wrote several pages, or you instructed him. I told him how many pages I would want. Question, how many times you want it written? Yes, ma'am. Question, you told him to write it 10 times? Yes, ma'am. You told him to write it as it was in the book. I told him to write the words not as it was in words. And then the question, now the words in the book are written in some script, some in join up. Yes, ma'am. You told him to write 5 times in script and 5 times in join up. I'm not sure about the exact instruction. And then there's further questions carry on the following page, but that's the only part I wish to take you to. The submission is that he's very vague about what instruction he gave to...
Well, nobody can remember 10 years later what instruction they gave. It's no. Absurd that they could.
Absolutely, but...
So it's just a matter of inference, really, as to what he...
Yes, save that in our submission. It's also... Firstly, it's relevant to the delay, but also it's relevant to the methodology, because this is so important to take a sample of handwriting that the exact question you would expect to have been recorded as to what instruction was given.
What's this difference in script and in join up? What is the difference that they're describing there?
Yes, I think there's probably an error there in that description. There's block letters, like capital letters, and handwriting not in capital letters.
Was this simply because the note itself had some cursive writing, some block letters, and they wanted examples of both?
Yes. Thank you. It might help with the photographs. I think I wanted to see a photograph in the electronic bundle 1836. There's Is
that one of the samples?
That's one of the samples.
Yes, so yes, you can see that there's a habit of using capital letter.
Yes.
Sometimes, not just for proper nouns, but for in other circumstances as well. Yes.
Yes.
So is this the note, or is this?
This is the forgive me, the sample
of Mr. Edwards?
So
This is one of his copies.
yes. So the index is at
chart.
1835, and so this is the. I think this, in fact, I might have made a mistake this morning. This might be the chart that was being shown by Mr. Major. I'm not entirely sure.
It looks like that because it's got various numbers
yes.
on it, I think.
Yes, so that's his workings.
Have we got the original, a copy of the original note? Anywhere?
No,
Yes, we do. I've seen it somewhere.
the original.
Not the original note itself, but a copy of it.
A copy of it. Yes.
Or a photo
So
of it.
we can see that if we look further through.
1840 is
Yes, 1840.
Thank you.
So the book
7.
1839, 1840 onwards. I think that's the clearest picture. It's the colour photographs. And in answer to the question on whether it was a loose paper or part of the book, we think from looking at it and the one photo that there was that it was part of the book rather than a loose paper. And that would, if we look at 1840, that would fit because have the name.
Unless on the left-hand side there are two staple marks. Perhaps it's been stapled onto a bit of cardboard or something. It's not quite clear.
Yes, I'm not sure they are.
It does look as if it's a page from a notebook.
Yeah. There's financial accounts on the left-hand side under her name.
We've got the name of the deceased on the left, and she put her name on her notebook. So we presume that's part of the notebook where she'd written her name on the inside cover. Then that would read across.
Yes.
Yes, that would read across as being part of the book.
The reason I was suspicious simply was if you look at 1839, it's the purple and black notebook, and against a yellow background. And if you look at 1840, it's a page stapled against the yellow background. It may be that it's the inside page of the book. I don't know.
It looks. We have one photograph of the scene where. There's one photograph of the scene where you can see the book actually opened up on the dresser.
I doubt much will turn it, so I don't distract you from your more substantive submissions.
Just for the note, it's at page 2181, and you can see it open. But having reviewed the record, there's not a suggestion put of a separate piece of paper put into the book. But
my lord, sorry, just if it helps, Mr. Major's evidence was that it was the first leaf of the Sikh notebook. That's at 808.
Thank you.
First leaf, 808.
So that fits with what it looks like in the picture.
Thank you.
I'm grateful. So in our submission as well, just staying with the record at page 658, this it's a question of Mr. Phipps. Number 12, did you seek any advice from anyone before you instructed Mr Edwards to give you handwriting specimen? No, ma'am. So I understand it, you merely did what you thought was appropriate. Yes, ma'am. There's a complete lack of care as to the collecting of the sample handwriting, and this, as is set out by the respondent, is the key plank of the case. Our submission is that the flawed obtaining of the sample and then lack of direction to the jury as to caution in considering the weight of that evidence from Mr Major, who obviously gave evidence that he considered the writer of the note to be Mr Edwards. Our submission is that this had undoubtedly an unfair effect on the trial, and undoubtedly was evidence which was put before the jury in such a way that if it was admissible, it was not couched in sufficient warning terms so that the jury approached it with caution. Rather, they were left to weigh up, did they prefer Mr Major to Mr Hayward? That lack of direction on weight in our submission is compounded by the learned judge's approach to Mr Hayward's evidence, and she refers to Mr Hayward's evidence without giving any assistance to the jury, but ultimately she also does not actually set out to the jury until prompted by counsel for the defence that his opinion was such that he could not say that Mr Edwards was the author of the note, and why he could not say that Mr Edwards was the author of the note because of the limitation on the handwriting sample. And my lady, my lord, that can be found. We set it out at paragraph 97 of our written case, and the opinion of Mr Hayward was in the summing up from 1743 to 1762. And then there was the prompt from counsel. It's at page 1776 of the summing up, if I can just take you to that. And this is all done in front of the jury, of course. 1776, it's at the end. Yes, my lady, there are two essential aspects of the defence have not been left to the jury. What are they? That would be firstly the expert Mr Hayward's opinion. I did tell them what Mr Hayward's opinion was, that he had said it was inconclusive. My lady, our notes of the evidence is that he said that Mr Edwards is not confirmed as one of the writers in relation to the Seek Mead handbooks who wrote it and so on. So it's raised there, which then the judge at page 178 then addresses the jury. You have heard the concerns. Sorry.
Who is this?
She addresses prosecution 1780. You've heard the concerns raised by the attorneys on behalf of the respective cases. So all this is carried out in the jury, and that's where at number 2021 she says that for the defence, Mr Hayward's opinion, Mr Edwards is not confirmed as the writer of the question document should have been left to you. In our submission, that footnote, it doesn't fully reflect what the evidence was, because throughout the summing up, Mr Major's evidence has been put to the jury that he has said that the author of the suicide note was Mr Edwards. And then this exchange at 1776 highlights the judge's approach, that she had told the jury that Mr Hayward was inconclusive. And of course, his evidence was he was only inconclusive because the methodology of the specimen taking was so flawed. So you were actually unable to make a conclusion, a safe conclusion, on the basis of that specimen. So that was completely lost in our submission in the summing up. And the jury would have been left with a certain Mr Edwards, a certain Mr Major, that Mr Edwards is the author, and an inconclusive Mr Hayward. But only inconclusive because of the flawed methodology.
Yes, the passage you referred us to at 1780.
Yes.
It wasn't just the treatment of Mr Hayward that Mrs Robertson was concerned with, was it? If you look at 1779 at line 920.
Yes.
What she was concerned about was whether murder was possible, having regard to a number of things, including the condition, evidence related to bathroom, the bullet hole in the door, the trajectory of the bullet, no gunpowder deposit on Mr Edwards or blood. Now, all that is matter which is addressed in the evidence that you're seeking to introduce today.
Yes.
But none of that appeared, that had been raised on cross-examination, I understand, and none of that appeared in the summing up, am I right, other than here?
Yes, that my lord, that is exactly correct.
And the judge's response was, these are, in my view, findings of fact that they'll have to look at, but I have heard.
Yes, yes. My lord, that is correct. And in our written case, we do rely on the absence as well of summing up referring to the defence points which were put in submission, although not...
Yes, because your argument is because of the loss of evidence and the inability to finance further research, these matters were simply assertions made on or points raised on cross-examination. But you're telling the board, as I understand it, that the defence case was that this was a small bathroom with a door opening outwards. The deceased was leaning against the door. We know the trajectory in general terms of the bullet. We know the bullet's in the door, so the door was closed. How on earth did Mr Edwards shoot her and get out?
Yes.
Without either blood on himself or more blood on the door?
Yes.
And these are, with the new evidence, rather potent questions. But all that the judge did was to say, well, these are matters the jury should consider.
Yes. Yes, my lord. I'm grateful for referring to that page as well. If I could just...
It may be of some importance.
Yes, we certainly do say it is of significance.
Have you got the reference for where Mr Hayward is challenging the expert evidence of Mr Major on the grounds that the methodology is flawed, as opposed to just disagreeing about whether you could identify the writer just from those samples?
Yes, if I may, I'll come to it. If I can just complete this point at paragraph 58 in response to his lordship. In our written case at paragraph 58, which is our grounds 5 and 6, and this relates to the judge's unbalanced and flawed summing up, and we set out there that she did not properly sum up or sum up at all in evidential matters or potentially for the defence at the trial, and that there's a list there of 10 issues which were then raised in that section by Miss Nita Robertson, and they weren't referred to in the summing up. So that's where we rely on it in the case stated. And then my Lord, in answer to your question, Mr Hayward, we can go back to the written case at page 228. 229. Yeah. Oh, and also, sorry, in the failure to summarise the defence case, I'm very grateful to Mr Hall. At page 2290, we also set out there that it's just been raised at paragraph 113.
Yes, I thought it was somewhere in your case.
Yes, it was.
But
forgive me for.
It just once one reads the additional evidence, obviously the judge didn't have that additional evidence, but if cross-examination on these matters had taken place, it is perhaps surprising that there was nothing in the judge's summing up on this matter as matters of dispute, i.e. the possibility of the murder taking place.
Yes.
And her response, which you record in paragraph 113.
Yes. And, my Lord, in relation to Mr Hayward, so it's 2,242. So it's 2,242, so we're on to the SFI. I
think it's just over the page, isn't it?
I'm very grateful. 223. So starting at paragraph 38.
But the crucial sentence, I think, isn't it, is at 1198 of his evidence, which is line 10. The opinion expresses that this Edwards or the writer of the specimen rent could not be eliminated. There's that peculiar phrase, he could be identified, but he couldn't be eliminated. I think the judge has taken that to mean, as I would take it to mean, he couldn't be identified.
Yes, yes.
Yeah, so the judge, I think, fairly summed that up. I think all I'm just asking you is that you said that that opinion was based on a flawed methodology, but the flawed methodology is actually referred to many, many pages of evidence back. It was just a precise linkage between the two. It may be that there isn't.
I'm not sure there's, in terms of the precise linkage, it might be useful to go back to Mr Hayward's statement. Just
page 2222 is.
bear with me. I'm very grateful.
Number.
I'm sure that's the one. Just bear with me. I'll just.
Yes, it's the consequently there at the end of paragraph 1. He says, in the absence of course of business specimen handwriting, their value for handwriting comparison purposes is limited, consequently a definitive conclusion of elimination.
Yes.
He's worded it rather not very satisfactorily, but I think what he's trying to say is that it doesn't look like he's writing from this comparison, but I can't be really sure that it's not him because I haven't got enough samples of his ordinary writing.
Yes.
Yes, I mean, there aren't sufficient samples to validate the exercise, so there does seem to be a critique of method.
Yes, thank you very much.
Thank you.
He refers to the other samples as the uncontested writing of the deceased, but it seemed from the passage you showed us, the exchange between counsel and the judge at 1779, that the case being put for Mr Edwards was not that they could assume that the other writing in the notebooks was by the deceased. I mean, there's that mismatch there.
Yes, it was explored at length. My lady's quite right in cross-examination, probably looking at the unsatisfactory nature of all of those documents. There wasn't actually any evidence producing the other books as being written by the deceased, albeit it probably wasn't really the best point that the defence were taking on it. It was highly likely that they were her handwriting. Sure. But they did spend, I agree, there was a lot of questions around that, but I don't think it really went anywhere. And I'm not quite sure where it was going with respect to... It might have been just to show the unsatisfactory nature of how all of the handwriting was dealt with, that none of it was produced properly. And so, my Lords, returning to the written submissions, we really set out our position at from paragraph 94 to paragraph 98 on the flawed methodology, and then the compounded by the summing up and compounded by other elements in the case, which in our submission, adding it all together, makes the conviction unsafe. And I refer to other elements in the case. It's really coming back to the fact that this was the expert evidence that the jury were left with. And in our submission, it may well have taken an enhanced position to the jury in light of everything else having been destroyed and no other forensic evidence, positive forensic evidence, effectively, for them to bite on. Here was positive forensic evidence, as was put by Mr Major, albeit, of course, handwriting opinion. It is an opinion, it's not a science. And in some ways, his opinion reached almost scientific levels following through in the summing up with how it was presented. My lady and my lords, the other aspect of the case in terms of prejudice and unfairness is the police interview. I can probably deal with this fairly shortly. We set it out in our written document at page 2284 from paragraph 99. And the Court of Appeal, in its judgment, just for the reference, it's at page 1941, found that the judge ought to have directed the jury that the various theories, speculation and so on by the police were not evidence. However, the Court of Appeal found that there was no prejudice to Mr Edwards, as he had given evidence himself that their relationship was a good one, and the defence had evidence from Mrs Harris, for example, that there was never any arguments that she was aware of between them. In our submission, that is an error on the part of the Court of Appeal, in that these were suppositions put to the defendant by police officers, and they may well have gained an extra layer of potential strength other than a mere smoke around them, in that the police were meant to investigate. They were putting suppositions to their suspect, and those suppositions and theories were placed in front of the jury for them to consider. And in our submission, the fact that the jury were not directed, that the police questions were not evidence, and the police questions contained such damaging suggestions of motive and violence against Mr Edwards, which has never been sustained in any way by any evidence in relation to Mr Edwards. In our submission, that may well have added to the overall unfairness in terms of the verdict.
Ms Brimlow, there was no discussion, was there, of the judge with counsel before summing up of what direction should I be giving? No. I know she asks at least once at the end, and possibly also at the end of a day, is there anything I've left out? But no draft directions or anything like that.
No draft directions. In terms of admissibility exclusion, the submission clearly is that this should have been excluded. Right. But again, the point wasn't raised, but in our submission, the fact that it wasn't raised and then it was considered on appeal means that at this, the board can still consider what is the unfairness. And so now we're focusing on, is there an error by the Court of Appeal?
And were the interviews, transcripts, documents which the jury had with them in their retiring room?
It seems from this summing up that they took the interview with them in their retirement. It has an exhibit number to it. Again, I can find the page because I was looking into that myself.
That's my recollection, that they had it in documentary form.
Yes. It was initially read out by the officer into before the jury, but it looks from the summing up when she referred to the interview, the judge referred to the interview, that they had a document which they took away with them. But I can clarify that on the page number, but that's my understanding.
And it may be that apart from the indictment and the odd plan, that was the only document they had.
It may well have been.
Yes.
Yes. The final submission in relation to that, of course, and this is where it's looking at the balance of the lack of investigation into the content of the note, is that whilst the jury would have been aware that they don't have to consider motive, and in fact I think the learned judge set that out to them, undoubtedly that would have been a consideration of the jury, that they were looking at motive, and if that was the only document they had with them, there it was in front of them, motive, even though it was not actually evidence, and the jury would not have known what to do with that other than to use it against the defendant. The grounds 5 and 6, my lords, my lady, refer to the summing up, and we, as we've been making our submissions, we've been referring to the summing up, and it's, with all respect to the trial judge, its inadequacies, but also that the Court of Appeal erred by holding that the summing up was sufficient in that it got the kernel of the defence case, and that the additional detail and complaints were not ones which rendered the conviction unsafe. And we've referred to the failure to summarise the defence case at paragraph 112. So I'm very grateful to Mr Hall that the jury did have access to the interview record, and that can be found at page 1571 to 1572. That's where it refers to them having the document. My lords, my lady, looking at our written case on this, on the summing up, it starts at paragraph 106. We've addressed the board on the case of Lau, which is it's an authority which addresses something different, where the jury are obviously and palpably wrong in their verdict. This is not a submission in this respect. It is that the evidence that the jury had was presented to them in a way which rendered the verdict unsafe, rather than a perfect or near perfect presentation of evidence, which then the jury had obviously and palpably got wrong with their verdict. So it's not a Lau situation in our submission at paragraph 107. At paragraph 108 of our written case, we submit that the Court of Appeal was wrong to conclude it was adequate for the judge to state the kernel of the defence case, to give evidence of discrepancies in the prosecution case during the summary of the evidence, and to give examples of defence complaints about absent witnesses as the judge went along as being sufficient. It's our submission that this was a narrative which was very difficult for a jury to get assistance from in relation to weight and prejudice and balance, and in fact even linking to burden of proof appropriately. Burden of proof obviously is in the summing up, and the Court of Appeal referred to that. However, burden of proof is not in the summing up at appropriate times, which in our submission would include where the handwriting evidence was referred to, that the burden of proof should have been there to assist the jury as a direction on that particular evidence. In paragraph 110, we submit that the prosecution evidence was extensively and uncritically summarised by the judge, and we set out at paragraph 110 where this features. And as submitted before the short adjournment, there was repeated reference to lack of GSR on the back of the hand. It was repeatedly returned to, and we rely on certain page numbers of the summing up.
Which paragraphs is this?
Yes. Paragraph 110, little 2, page 2287. So perhaps if we just look at that very briefly on the GSR in the summing up.
Yes, I think you find it at 1552, again at 1554, and again at 1676.
Yes. Yes, I'm grateful in particular from 1554, the section of that page we rely on, because how it's a good illustration of how the gunshot residue was dealt with. And at number 15 and 16, as I said, you heard that evidence, but in relation to this case, none was found. This is straight after summing up on elevated concentration of gunshot residue, and that section of evidence when you have a closeness in the use of the firearm. And then 18, she says, so I don't know that I should go into details about the various levels, but for what it's worth, elevated level would indicate a large amount of gunshot residue and would arise from the firing of a firearm or being in the direct path of gunshot residue as it was emitted from the firearm, and usually that is within a distance of 9 inches, which is obviously the position here.
If you look at 1551 at the bottom line.
Yes, and 15.
In her address to the jury, Mrs. Palmer-Hanson was saying that this is significant to the absence of any gunshot residue on the hand of especially the deceased. And this is one of the things that she said you should look at carefully in deciding where the truth lies in this matter. So, I mean, it was being flagged up as a big issue in the address to the jury.
Yes.
And then there's the passage you refer to in 1555, 3 to 4. And I think it's again at 1676 when the judge summarises the prosecution case. There may be other references,
yes.
I don't know, but I spotted those 3.
Yes, no, my lord, I'm very grateful. We also have those flagged, and if I may add, not only in relation to the fresh evidence ground one, but also in relation to how this evidence was presented in the summing up to the jury at page 1552 from number, all of that page in fact,
yes.
But at number 19, if you are left in a state of reasonable doubt, having examined all the evidence, then the law says you would have to resolve that doubt in his favour. And if you believe him when he says that he had nothing to do with it and that Miss Vasquez had taken his gun and shot herself, then you will have to resolve in favour of him. It's only if you're satisfied to the extent that you feel sure that on the evidence that's been presented, then and only then would you return a verdict which is adverse to him. And the summing up and returning to the GSR continues at 1553, 1554, and we submit that yes, the burden of proof is just about directed, but it's not sufficient. There's not a sufficient direction of the burden of proof on the prosecution that they must prove that their case in this. There is some pushing it back on if you believe the defendant. And at page 1554, the bottom of that page going to 1555, she says, so if you are very close to the firearm, when the firearm is discharged, then you would expect to find elevated levels of gunshot residue. So there it's very clear. And then she carries on with trace and so on. And it's not balanced in this section in our submission by defence propositions, but also the defence propositions, of course, did not have the fresh evidence that we seek to rely on. That, in fact, this is wrong. It does not necessarily mean that there would be gunshot residue because of the methodology of the swabbing that had been carried out on the back of the hands because of the lack of the sensitivity.
She also doesn't say, after, for example, the passage from 1676 to 1677, but bear in mind that there was no gunshot residue found on Mr Edwards or on the nightdress.
Yes, my lady, she does.
Oh, she does say that?
Yes.
I think she points it out elsewhere.
She points it out that there's no residue on him at one point.
Well, she says refers to his clothes. Does she refer to his hand?
I'd have to
Maybe she does,
search through
this, but she certainly, as my lady says, she hardly highlights it.
Yes.
It's just that I find 1676 really quite a powerful statement as to what the prosecution case was.
Yes.
1676.
Yes, starting at letter 13, line 13. Superintendent Hibbert indicated he would expect an elevated level of gunshot residue on a person's hand because the gun's a revolver. And in this case, it's being said by the prosecution, if the deceased had in fact killed herself and she had fired that gun, then her hand should have elevated levels of gunshot residue. However, when her hands were swabbed, none was found on the back of her hand, and in particular her right hand.
Yes. Yes, I'm grateful. And
was that even matched by pointing out that there was none found on Mr Edwards' hand either?
No. And my lords, my lady, we summarise, there may be other passages, but we summarise the passages that we relied on in making these submissions at our written case at page 2289 at paragraph 111, where we submit that the judge routinely and repeatedly emphasised the prosecution case over and above the defence case. And at little 1, the judge's repeated statements of the prosecution case that the lack of GSR on the deceased's hands and nightdress meant that the death was not suicide. And we've been to some of those passages now at 1525, 1676, and which were Hibbert's, the summary of Hibbert's evidence. And then the forensic scientist Dunbar's evidence was summarised in a similar way at 1551, and then 1553, going up to 1555. And our submission is that even putting to one side the new evidence on the shore revealing the fundamental unreliability of these conclusions, although the judge does state that Mr Edwards' shirt had no traces of GCSR, and that can be found at 1553. So she says that before that section we were looking at.
That's his clothes, but I couldn't see that she actually mentioned the fact there was none on his hand, which was pretty important.
Yes, I don't think she does mention the hand, but we'll have to have a search through again. Yeah, that's what, when we trawl through it initially, that's what we found on the balancing, as it were, from the defence perspective, not on the hand. And we've made the points in relation to the handwriting evidence, and also we've made the points in relation at little 3 to Mr Phipps's evidence. With the usual direction to the jury was it's up for you to say what you make of it, even though there was clear inconsistencies, delay, memory loss, and so on and so forth on that pointing out of the note.
I should alert you, Ms Brimley, that you have used up your time.
I have.
But you are entitled to eat into your reply time in order to present your case in a coherent way.
Yes.
But I think, in fairness, I must alert you to the fact that you're now into that time.
Yes, I'm very grateful. My lords, my lady, the only aspect that we hadn't turned to was the proviso, which we invite not to apply the proviso.
If I can go back to 112 and 113.
Yes.
I would find it helpful if tomorrow, or as soon as possible, someone were able to produce a list of some examples where these matters were raised with key Crown witnesses on the cross-examination.
Yes.
Just to satisfy the board that these matters which the Defence Counsel raised at 1779 to 180 were matters which had been sufficiently ventilated to justify that request.
Yes, absolutely.
Thank you.
Yes, my lord, my lady, thank you very much.
Thank you very much. Mr Poole.
My lords, my lady, I'm grateful. I propose to deal first with the constitutional appeal, and really in so doing address the issue of delay and really the impact that the appellant says delay had on the fairness of his trial. I'll then deal with the conviction appeal, taking the 6 grounds of appeal in the order they're dealt with in the respective parties' cases, and then finally and briefly deal with the proviso. My lords, my lady, at paragraphs 5 to 11 of our printed case, we've set out an overview of the respondent's position on both the constitutional and conviction appeals, and I don't propose in opening to repeat what's said there, but simply to make 2 short, overarching submissions. The first is we submit that the complaints made by the appellant, taken singly or cumulatively, cast no doubt on the safety of his conviction. And second, neither, we say, does the new evidence relied on by the appellant justify such a view. As regards that new evidence, we do resist its admission, and I'll explain the basis for that resistance when addressing the grounds that rely on the new evidence. But obviously, we're content for the board to consider the fresh evidence de bene essay. Moving then to the constitutional appeal. My lords, my lady, we've summarised our position. It's paragraph 11 of our printed case, which is page 2307. And then we develop it later on at paragraphs 53 and 54, which starts at page 2325. At the outset, and as my Lord Hodge noted at the outset of the appeal, we obviously accept that there's been unacceptable delay in this case, and the issue for the board really is what relief, if any, should be granted. Now, even allowing for past and current problems affecting the administration of justice in Jamaica, we obviously do not oppose this board making a declaration that the 10-year delay between the appellant's interview and trial and conviction breached his right to a fair trial under the Constitution. No declaration, also no express declaration, has been made to date, although we do note and draw the board's attention to paragraph 49 of the Court of Appeal's judgment, which is page 1926, where the Court of Appeal expressly recognised the delay and the unacceptability of such delay. Moreover, I think it's right, when looking at the question of relief, to note that the Court of Appeal did take into account the period of delay when reducing the period before which the appellant's eligible to parole from 35 years to 20 years. And you see that at 1962 to 1964. That's the Court of Appeal's judgment. Now, it's for those reasons, so namely the public recognition of the unacceptable delay by the Court of Appeal, the factoring in of delay in reducing the tariff period, plus the fact that the appellant was on bail for, I think it's 8 of the 10 years of delay, that we say no relief beyond the declaration is warranted. Now, the real issue raised by the Constitutional Appeal is whether the appellant's trial was unfair. We say, as there was no application to stay or dismiss the proceedings, that is what the board is focusing on, as opposed to whether or not it was fair to try the appellant in the first place. And as to the unfairness of trial, our overarching submission is that the delay in commencing trial did not result in an unfair trial.
Mr. Ball, just to pick you up on a small point, and maybe nothing turns on it, but you rather give the impression in the page that you took us to that the Court of Appeal knocks off 15 years for delay. But that's not actually correct, is it? They knocked off 5 years, I think, before he's eligible for parole.
My Lord,
they took it down to 25 years as a starting point for other reasons.
My Lord, that's right. Yes. I'm grateful for that clarification. It's the fact that delay was taken into consideration when reducing the tariff. But my Lord, you're right as to that period.
Yeah. There was, I think, a 5-year period.
Yeah, my Lord. Yes. Correct. Now, I'll make good the submission that the delay didn't result in an unfair trial in a moment. Before doing so, I just want to refer the board to 3 cases, and we deal with these cases at paragraphs 29 to 31 of our printed case, which starts at page 2314. I can take the cases fairly swiftly because, first, the board will be familiar, and second, my learned friend has referred at least to 1, if not 2 of them. The first is the case of Ibrahim and Felton Magistrates Court, which your Lordships and my Lady have at page 2694. Ibrahim was a joined appeal. Both concerned the destruction of evidence that was said to have been essential to the defence and the jurisdiction of the court to stay criminal proceedings for abuse of process. Refer the board to Ibrahim for what is said by Lord Justice Brooke at paragraph 27, which is the bottom of page 2702. And the point is made there that it is commonplace for defendants to rely on holes in the prosecution case, and often the absence of evidence is likely to hamper the prosecution as much as the defence. In my submission, both points are relevant when considering the specific complaints arising from delay that the appellant makes in his case and the effect it's said to have had on his trial. The next case is a case, the Queen and RD, which the board has at 2765. This was a case in the criminal division of the Court of Appeal arising in the context of allegations of historic sexual abuse, and the period of delay here ranged from between 39 to 63 years. I invite the board to look at what was said at paragraphs 14 and 15, which is on page 2771. And the Court of Appeal makes the point here that the length of delay itself obviously proves nothing, and what is important is the effect. And then the key passage for present purposes in my submission is paragraph 15, namely the need to distinguish between mere speculation about what missing documents or witnesses might show and missing evidence that represents a significant and demonstrable chance of amounting to decisive or strongly supportive evidence emerging on a specific issue in the case. Submit, that's what the board should be looking for again when looking at the complaints that are made in the present case on delay. And then finally and briefly, the third case is a case called Queen and Allen, which the board has at 2680. And I highlight this case really for an example of the principles we've just been looking at in action. As I said, the board has this at 2680. Part of the appeal was against a refusal to stay criminal proceedings on the basis that there had been a gap of 13 years between the initial investigation and the defendant's arrest. And in that time, a number of exhibits from the first earlier offence were no longer available. As I say, this is a case where the principles in Ibrahim were applied, and refer the board to paragraphs 29 and 30, which starts at 2689. And the Court of Appeal, in this case, held that the DNA evidence provided the prosecution with a firm evidential basis for its case, and there was nothing in the missing evidence which might taint that DNA evidence. Paragraph 30, Lord Justice Simon repeats the point made in Ibrahim regarding the defence being able to put the holes in the prosecution's case and cross-examine why no material was no longer present. The Court of Appeal concluded in that case no basis to say the judge was wrong to refuse the application to stay. Now, by analogy to this case, I submit that Mr Major's evidence, his analysis of the suicide note, provided, to use the expression of Lord Justice Simon, a firm evidential basis for the prosecution case. And I'll obviously address the criticisms that are made of his evidence when coming to the conviction appeal on ground 3. But I submit in the present case that the defence was able to put before the jury the holes in the prosecution case by cross-examining the Crown witnesses as to both the quality of the investigation and why certain material was no longer available. And therefore, in my submission, notwithstanding the delay and notwithstanding the fact that material was destroyed prior to trial, I do submit that the appellant had, in fact, a substantial amount of material that could be used to challenge the prosecution case. And I've set out at paragraph 33 of our printed case, which is page 2316, a list of that material. Just, if I may, take the board through that list. We first have the evidence of Mr Hayward, that the writer of the specimen writing, so in other words, the deceased, could not be eliminated as the author of the note. You next have the absence of any forensic evidence supporting the Crown's case that the appellant shot the deceased. You next have the photographs of the crime scene showing blood patterns, the position of the deceased body, the location of the gun, the height of the bullet hole in the door, all of that being said by the defence more readily being explained by the deceased shooting herself. You have the evidence from the pathologist.
You accept that those matters were put to the witnesses on cross-examination, do you? Or?
Well, my lord, I'm afraid it's not a yes or no answer, because, for example, take blood patterns. It was put to Crown witnesses that the cleaning of the scene prevented any blood spatter analysis, and one of the witnesses for the Crown said, I'm not an expert in blood spatter. And when I come to the fresh evidence, what is apparent in my submission is that there was no Crown evidence led on blood spatter. And you have the evidence of Miss Leake that I'll come to, that there was no blood spatter experts on Jamaica at the relevant time. But as I say, I will come back to that. The next point you have about the upward trajectory of the bullet, that evidence was given by Dr. Prashad, who stood in for Dr. Shasiah not being available. Again, that was said by the defence, more readily explained by the deceased shooting herself. You have the size and layout of the bathroom, which the defence said made it impossible for the appellant to have fired the fatal shot. The jury had a visit to the locus in quo and would have seen for themselves the dimension of the bathroom. You have the lack of motive, and you have certain discrepancies in the prosecution evidence, and I'll come on to dealing with the main, arguably the main one, the appellant says, which is the discrepancy between Sergeant Brown and what is said by the appellant about seeing the suicide note. So just taking short...
I want to know the answer to my question as to whether there was any evidence as to whether Mr Edwards is right-handed.
I think the answer is that there's certainly no evidence.
Unless he was left-handed, she was sitting in the left-hand corner of the bathroom and was shot through the right temple. It's impossible to see how he could have got his right hand into that corner and sort of shot her in that way.
Well, my lord, the defence. What we haven't got, unfortunately, is, as is often the way in these cases where you get the transcript, you haven't got the defence closing, you haven't got the prosecution closing.
No, so we don't know what points were made in argument.
Obvious in my submission, the points that would have been made by the defence. And the reason I say it's obvious is because you can see the points that would have been made by the defence in closing by the points that are raised with the learned trial judge at the end of her summing up when they say, what about this, what about that, what about the other? And the judge said, and I'll come on to this because I can see certainly my Lord Hodge is concerned about that not being adequately summed up, and I will deal with that when I deal with the summing up. But just perhaps to put a marker down at this point, it isn't right in my submission to say that none of those points that are then listed by the defence did not feature in the summing up. So, for example, the trajectory of the bullet features in the summing up. The dimensions of the bathroom feature in the summing up. My point, to foreshadow what I'll expand on probably tomorrow now, is that these would have all been points obvious to the jury. They may not have been given the judicial imprimatur by featuring in a section of the summing up with analysis, but they would have been obvious points to the jury, particularly having visited the locus and having seen the photographs.
But, so, if a judge chooses, as a method of summing up to adopt a narrative approach to the evidence that's given, it is surely odd that these points, if they were focused on, didn't feature in her summing up. Because it's a very long summing up by any standards.
My Lord, I would accept that if there's a cardinal line of defence that is placed before the jury by the defendant, and that finds no reflection in a summing up, it would in general be difficult to say that conviction is safe. However, I say the present case is far removed from that example. The appellant's cardinal line of defence was, I knew nothing about the shooting and the deceased committed suicide, and the jury were repeatedly reminded of that during the summing up, and we've given the board those references. Paragraph 14C of our case, page 2310, and I think I've given perhaps half a dozen references to the relevant parts of the summing up, and I won't, at this stage, take the board to those.
But that's the difference between an assertion I didn't do it and an assertion I couldn't do it, couldn't have done it. The latter is potentially more powerful.
My Lord, as well as reminding the jury of what I say the cardinal line of defence is, that I do say the jury would have been well aware, and this point I made a moment ago, of the defence position in respect of each strand of circumstantial evidence based on the cross-examination of the Crown's witnesses, the closing speech, and that request for additional directions. But as I say, I'll come to that because that's jumping to a certain extent to the grounds 5 and 6 of the conviction appeal.
Yeah, please take it in your own order.
My Lord, I'm grateful. I obviously would like to address any concerns the board has as I go along sensibly. But the point I was just making on delay, as a sort of overarching opening point, is there was extraneous evidence in my submission of real substance to assist the jury assess whether the appellant's account was to be accepted. And it could be said that the appellant had available to him significantly more material to be deployed during cross-examination than is often the case of a trial of an incident of this nature, where you have staged suicide effectively put against suicide. There are 7 specific delay complaints, if I can call them that are made by the appellant in their written case. And I'm going to deal with those. We've dealt with them in writing at paragraph 54 of our case, at page 2325. But I do just want to run through those 7 delay complaints. The first complaint is, essentially, it said the Crown is to blame for the delay. Now, the Court of Appeal found that the delay could not be ascribed to willful delay or lack of diligence by the prosecution, and that's paragraph 50 of the Court of Appeal's judgment, page 1927. And in my submission, the board should not quickly depart from that conclusion of the Court of Appeal. The Court of Appeal were provided with the document that is in the record. It's page 2154, which was a chronology put together by the Crown, setting out the various dates on which the case came before the court at first instance. And what is apparent from that document is that there were a number of occasions on which the Crown was unable to secure attendances of witnesses. It is equally apparent that there were a number of occasions where the defence was unable to proceed. And
well, you make it sound as though it's evenly balanced, but it was 15-6, wasn't it?
My Lord, if we're talking numbers, yes, but if we're talking potential effect, then arguably it goes against the defence. Because if you take, for example, the third bullet point at 2154, the trial commenced and had to be aborted as the defence requested an adjournment to call handwriting expert evidence. And that led to a 3-year delay. And so it is difficult, if not impossible, at this far remove, and I say that with respect to the board not being in the position of the local Court of Appeal, who obviously is better placed to determine whether delay could be ascribed to either willful delay or lack of diligence by the prosecution. It is impossible in my submission to go behind that finding of the Court of Appeal. And so there's simply no basis to interfere with that finding in my submission. The second complaint, the destruction of evidence in 2009. Now, the Court of Appeal deal with this at paragraphs 59 through to 68 of its judgment. And in summary, the Court of Appeal held that the destruction of evidence had an effect, but did not cause any appreciable disadvantage to the appellant. And in my submission, that is a conclusion the Court of Appeal was plainly entitled to reach, and one that is not shown to be wrong by the submissions made to the board or the fresh evidence. Now, there are 3 specific destruction complaints, if I can call them that, made by the appellant. The first is, it is said that the Court of Appeal overlooked the firearm and its destruction, and that prejudiced the appellant because it prevented him having the gun analysed for the presence of DNA and fingerprints. So it said, had the deceased fingerprints or DNA been found on the gun, it would have supported the defence's case of suicide. Now, the short answer to that submission is that any missing gun forensic evidence, I say, falls squarely in the speculative evidence category as opposed to the decisive or strongly supportive evidence category, to use Lord Justice Treacy's language. But 2 further, slightly more specific points. First, what do we actually know about the gun from the evidence? Well, Corporal Arthur's evidence was that he took the gun and put it in a sealed evidence bag. You have that at 171 of the record. Superintendent Phipps's evidence was that the gun was not fingerprinted because they could not lift fingerprints from the gun using powder. That's 664 of the record. Now, that evidence was not challenged at trial, and neither is that evidence challenged by the fresh evidence. Now, Miss Shaw and Mr Mastaglio were invited to comment on Superintendent Phipps's evidence, and they stated that the examination for fingerprints is outside the field of expertise, and you have that at page 2104. There's therefore no evidential basis to support the contention that the gun could have been tested or usefully tested for fingerprints, either at the time of the investigation or at any time thereafter.
What about DNA, Mr. Paul?
My Lord, it could have been tested for DNA. I accept that, but the difficulty with that being said to be of any use to the defence is the second point I was coming on to make, which is the Crown's case was the appellant had staged the scene to look like suicide, and we know from the photographs that the gun was found on the deceased's lap. In my submission, the presence, had the gun been tested and had the gun been found to have DNA or fingerprints on it of the deceased, it would have offered little, if any, assistance to the jury in determining the key question for them, which is who shot the deceased.
I wonder about that. If the gun was found not to have any DNA on it from the deceased, then that would have helped the prosecution case considerably, would it not?
Well, my Lord, it's like the GSR. It's really like the GSR point that I'll come on to in a moment. These are given the prosecution case and the defence case. These are neutral points for either side in my submission. They would not. This case effectively came down to the handwriting analysis,
yes,
and the jury accepting Mr. Major's evidence that the appellant wrote the suicide note.
Well, it came down to that in reality, because that was the only evidence that the prosecution had. But it does seem a lot of emphasis was put on the absence of gunshot residue,
My Lord,
which turns out to have been a false point.
Well, my Lord, if I may, I'll come on to, because that's a separate point. Yeah, but I accept that. I certainly accept that one strand of the evidential rope was lack of GSR on the deceased's hands. I accept that point was put before the jury. Sorry, my lady.
Going back to the gun and the lack of DNA, you say if there'd been none of the deceased's DNA, that would have helped the prosecution. If there had been a big fingerprint and her DNA on the trigger, it would have been put to Mr. Edwards. That was part of your staging of the suicide, to make it look as if she had pulled the trigger. Is that what you're saying?
Well, my lady, if that was the evidence, then I'm sure that would have been put, because it was the Crown's case. This was a staged scene, and obviously part of the Crown's case was the Crown would say the suspicious handling of the weapon, even on Mr. Edwards' own case, that he picked the gun up upon finding the deceased's body, and the Crown invited the jury to find that was suspicious and something that a trained police officer and someone with some experience of crime scene investigation would not have readily done.
We clearly don't have the summing up by counsel to the jury, but I would be interested to know, and this is for tomorrow, I mean, what was it that the Crown relied on to say that it had been a staged suicide? But that's not for just now.
Well, my Lord,
I don't want to take you out of order.
No, my Lord. As I say, I'm more than happy to deal with questions as they come, if I can. I think probably the best place to find that is in the no case submission. Well, actually, my Lord, in the summing up, actually, maybe an even better place. So in the no case submission, the prosecution, as you'd expect, gave reasons as to why the case should extend beyond half time. In the summing up, the judge listed what the prosecution relied on as the circumstances that point in the direction of the guilt of the accused, and it starts at 1675, and it runs through to 1681. And I think, although they're not numbered by the judge, I think there are, on my count, about 9 factors. So and these are dealt with by my learned friend in the appellant's written case, and then I respond to them, and so I'll probably deal with these again tomorrow. But it's examples of opportunity, the fact it was his gun, the fact that the deceased was aware that he was leaving Jamaica. Fourth point at the bottom of 1676, the lack of GSR. Over the page at 1677, there being no room on the dresser for the holster. Over the page, 1678, lack of interest.
What was that?
Well, that would, I would have to say on any view, not the prosecution's sort of strongest point. But I think it was being suggested by looking at photographs of the dresser. There wasn't actually any room for the holster to be.
Well, he must have had to put it somewhere. Presumably, he wasn't wearing it in bed with her.
Well, as I say, it certainly wasn't the Crown's strongest point. At 1678, the appellant's lack of interest in the suicide note. The point being here that even leaving aside the conflict of evidence between the appellant and Superintendent Phipps as to whether the appellant was aware of the note prior to it being presented to him for the first time at the police station, he says, the appellant's evidence was that he knew something of the note at the time because he heard Sergeant Brown talking about a suicide note, and the point being made by the prosecution was that he didn't show much interest or concern, having heard that there was a suicide note. Bottom of 1678, the fact he ran past the bathroom door. I think it was suggested at one point that as a trained officer, he should have, in fact, known where the gunshot had come from, and so wouldn't have run into the living room and should have known that it came from the bathroom. And then the two final... It wasn't
exactly an enormous house, was it? Well, he woke up and there was a loud bang, and didn't presumably... I don't know what the basis was for suggesting that because he was a policeman, he must have been able to pinpoint.
Well, I think to be fair, when you look at the cross-examination, it's one of those questions that I think the prosecuting counsel starts asking and then doesn't follow through with any vigour at all. And then 1681, the last 2 points. The fact that the deceased's hand was not as described by Mr Edwards if she had killed herself, and then finally the staged scene, so the position of the gun in the deceased. So I'm reading now 1681, line 13. So the Crown state, the position of the gun in the deceased's lap, condom on the floor, things that would tend to give credence to the items being put there in order to set a stage for this to be looked at upon as suicide, a matter that you can take into consideration. So I think that's probably an answer to Lord Hodges' question. Seeing the closing speech, those are what look to be the circumstances the Crown were relying on.
Yes, thank you. What I was wondering is whether there was in evidence any attempt by the police witnesses to explain how, if the lady was shot while sitting down and leaning against the door, how the appellant got out of the bathroom, opened the door, which opened outwards, got out of the bathroom and closed the door. But that doesn't seem to have formed part of the focus of the case. Would that be right?
That is right, my lord. Certainly none of the Crown's witnesses are taken or led in examination in chief, and it is really a point for cross-examination in my submission on the facts of this case, and there's no cross-examination along the lines of it's implausible, isn't it, that the appellant would have been able to shoot and then get out of the bathroom without leaving some trace.
There was no cross-examination?
There's no cross-examination on that point. The cross-examination effectively rather sort of left hanging in the sense that a number of points were put about the failure to carry out best practice in allowing the scene to be cleaned, failing to take certain measurements, failing to test for GSR and fingerprints and DNA. And it's then not carried through to any points being put along the lines that my Lord Hodges suggested.
So, Mr. Bill, you just referred us to 1675 to 1681, and is Ms. Brimley right? There is no equivalent summary case for the defence, or what the defendant's answers are to any of these 7 points?
It is fair to say that there is no equivalent list or analysis of the equivalent defence points. Really. And now, as I say, I will come on to deal specifically with the summing up when dealing with grounds 5 and 6. And your lordships and my lady have a sort of flavour of my submission in that regard, which is that the jury would have been well aware of all of those points being made by the defence. The second, I'm calling this destruction complaints, is the destruction of the deceased's nightdress and underwear, which is said to have caused prejudice. And the reason that it is said to have caused prejudice is the defence were precluded from effective cross-examination, it said, of 2 of the Crown's witnesses as to blood spatter and the position of the deceased when the firearm was used. And the 2 points in response to this. First, the defence did not call a blood spatter analyst at trial, as they could have done. And that foreshadows a point I'll deal with when dealing specifically with the fresh evidence. Miss Nita Robertson's affidavit, she being lead trial counsel, explains that the decision was taken to use the defence resources to obtain their own handwriting expert. 2146 is her affidavit. And as I say, I'll come back to...
well, to say that they could have done, I mean, if you've only got enough money to pay for one expert, it's hard to describe that as saying it's just a free choice not to call them a blood spatter expert, isn't it?
My lord, two things in response. I think first I would say it rather shows what the defence rightly saw as the key to this case, the handwriting evidence. Hence, they got their own handwriting expert. And I say that shows that this was not a case that either side saw as turning on, if I can call it, the forensic scientific evidence, so GSR, blood spatter, DNA, fingerprints.
Well, I suppose they were responding to the evidence that was produced by the prosecution. You might have hoped that the prosecution would have, there would have been some evidence obtained for the prosecution of the blood spatter, which then could have been used by the defence if it was helpful to them. You normally expect that. It's not normally left down to the defence to have to produce forensic evidence if they want to try and prove their case.
Well, but no, that underscores in my submission that the point that this was not a case that the prosecution saw turned on blood spatter or DNA or GSR for reasons I will make good, or at least attempt to make good when looking at the fresh evidence. But the point here on this destruction complaint is that there was no witness at trial that was in a position to express a reliable view as to blood spatter had they been cross-examined by reference to the actual garments. And that's the prejudice that is being relied on here, that the absence of the real garments prejudiced the defence from cross-examining 2 of the Crown witnesses. Second point in response is that having the actual garments there cannot be said to be decisive or strongly supportive evidence in my submission in favour of the defence. The defence case, which the jury would clearly have understood, was that the bullet hole, the position of it in the door, the blood spatter and the position of the deceased were all more readily explained by the deceased having shot herself while being seated on the bathroom floor. And the defence was able to make that point effectively by reference to the photographs that were taken at the scene. Now, it is right to say that Miss Bridson, one of the Crown witnesses, she analysed the nightdress and the underwear for blood and semen, and she said in cross-examination, her words, it would be better if we had the garments in court. But she nevertheless expressed a view that the deceased was more likely lying on her back was her evidence, which is, you see that at 324 to 325. But as already submitted, she's not a blood spatter expert. She couldn't assist the jury beyond the jury's own observations looking at the photographs in my submission. The third and final of the destruction complaints comes to the point that I've addressed.
Well, she was lying on her back on the floor.
Well, my lord, that was Miss Bridson not being a blood spatter analyst and being someone that was analysing the garments for blood and semen, and her evidence was more likely lying on her back.
But she was lying on her back when she was found because the door had been open and she had fallen.
Side, at least.
On her side. Well, I think there was, I think somewhere I read that she had been moved to take the photographs of her. Right.
I'll check. I'm not saying your ladyship's wrong. I don't recall seeing it myself, but I will check that.
By the time Mr. Edwards opened the door and the body fell back, she had been dead for how long? Roughly seconds or minutes, or would she have stopped bleeding by then?
Well, the pathology evidence was that death would have been instantaneous. There was no evidence as to the volume of blood that would have been sort of emitted following the shot. The evidence on timing was Mrs. Harris said she heard a shot and she then saw the appellant. I think she said she used connotes sort of rushing into the room or hurrying into the room. She's not cross-examined, or she's never asked how many seconds, how many minutes. So the appellant's evidence is initially in his interview, I think he says, I walked. And this is something that the prosecution cross-examined him fairly extensively about, because he says, I walked into the living room. In his examination in chief, he then says, I walked briskly, and the prosecution cross-examined him about the change from his interview to this, and his evidence in his interview is it was a matter of seconds, not minutes.
But he had no blood on him when he walked into the living room and was seen by the mother-in-law.
It was no part of the prosecution case that the appellant had blood on his clothing or his hands, and Mrs. Harris doesn't give evidence that there was any blood. Obviously, there being a period of time before the police then arrived at the scene, but it was no part of the prosecution case that there was blood, the deceased blood, found on the appellant. No, my lord. The third destruction complaint relates to the lack of gunshot residue, which we've discussed briefly already on the nightdress. And this point is made in support of a number of complaints in the appellant's case. But for present purposes, just want to focus on how it goes to how the complaint is framed in terms of destruction of garments, and how that is said to have prejudiced the defence effectively, because there's now no opportunity to revisit those items and consider retesting. And 3 points in response to this. And first is really a similar point made in respect of blood spatter, which is the appellant chose not to obtain his own gunshot residue analysis. It was in my submission open to him to do so. Second, even assuming it would be possible to retest the garments so many years after they were collected, and obtain reliable results. And the reason I say that's because evidence is given in the fresh evidence that passage of time is but one factor that can lead to particle loss. And when you're talking about gunshot residue, it stands to reason that if you're testing many, many years after the event, the reliability of those results would be questionable. In my submission, it is pure speculation to suggest that the results of such testing would have had any significance. And I've really made this point already, which is this, that the result would either confirm Mrs. Dunbar's evidence that there was no gunshot residue on the nightdress, which would not have advanced matters, or it would have found gunshot residue, But even this would not have assisted the jury because gunshot residue could have been deposited whether the shot was fired by the deceased or whether it was fired by a third party. And that's confirmed by Ms Shaw in her joint report with Mr Mastaglio, which is page 2111. It's answer Roman 10 little d. Now, I do accept that had retesting identified gunshot residue on the nightdress, it would have called into question the reliability of the testing and the lack of GSR on the deceased and the appellant's hands. But again, that, in my submission, would have been of no real significance, as the presence of GSR on either could be readily explained on either the Crown's case or the defence.
The absence of gunshot residue or the presence of gunshot?
The presence, it being the appellant's own case that he handles the gun afterwards.
Yes, but it would have, if the reliability of the GSR testing that was in fact carried out was called into question, it would have removed one of the big points that the Crown was making to the jury, that it was significant that there was no GSR on the deceased's right hand.
But my lord, the same would though apply for the Crown and the defence. It's the same as absence.
The proof is on the Crown. One of the big points they were making, as we've seen from the various passages we've looked at, notwithstanding that it seems from your written case that the witness was a lot more guarded than the Crown submissions were. One of the big points was made that was that the absence of GSR on the deceased's hands pointed to her not having fired the gun. So if the evidence called into question the reliability of the testing that was carried out, that might be not insignificant.
My lord, as I've accepted already, the one strand of evidence relied on was the absence of GSR, but the appellant relied on the absence of GSR on his hands in support of his defence, and the board can see the reference to that at 989 line 24 to 990 line 3. So insofar as the jury considered lack of GSR on the deceased's hands and nightdress, they could only have concluded in my submission that it offered them no assistance in resolving the main issue in the case, namely whether this was murder or suicide.
How do we know that? We know that.
Because, my lord, there was no GSR found on the appellant.
Yeah.
And the jury have convicted the appellant of murder.
Yes.
And so the absence of gunshot residue can have played can have been of no assistance in them resolving the core factual issue that they have to resolve in this case.
Well, that wasn't how the case was being put. It was being put as a highly crucial point by the prosecution.
Well, my lord, you've heard my submission. I say it was certainly relied on, and I don't submit otherwise. It was not, though, the key to the case. The key to the case was Mr. Major's handwriting and the fact that he concluded that the appellant wrote the suicide note.
Was it put to Mr. Edwards in cross-examination that he had washed his hands after?
My lady, no.
You referred to 989-919. What was that document from? What part of the proceedings was that?
My lord, let me check. I think that's the...
It's a no-case submission.
That's a no-case submission, my lord, yes.
So that wouldn't be in front of the jury?
No, my lord. That's to make the point that is something that obviously the defendant, the appellant, relied on. And my lord, I'll find you I think you've got the reference in the summing up. Let me just find 50, I think it's 1553.
If that's the only reference, then I am concerned that that was a pretty serious flaw in the summing up, because a lot of mention was made of the absence of gunshot residue on the hands of the deceased. And I haven't seen any reference whatever in the summing up to the corresponding lack of evidence on his hand.
Well, Lord, that is a reference, and if there
No,
are...
it isn't. It's a reference to his clothes.
Oh, my lord, yes, that is, but...
Pages this way.
1553.
But the jury would have... The jury heard the evidence.
Well, you can't go on saying the jury heard the evidence in the summing up. If you're going to make a big point of the fact that it couldn't have been her, so the prosecution tell you, and if you believe that it couldn't have been her because she had no gunshot residue on her hand, you might have thought there was at least an obligation to point out, well, if that's a good argument for them, then it can equally be said by the defence that there was no gunshot residue on his hand. And we don't have that. All we have is a passing reference to there being none on his clothes.
Well, yes, you have the reference of 1553, and if there is another reference, I'll give the board any other reference tomorrow. You also have the extensive cross-examination of Mrs Dunbar on this point, which would have left the jury with the clear impression in my submission. I've set out, so paragraph 13C of our printed case, which is page 2309, the reasons why I say the jury would have been left with the clear impression, having heard Mrs Dunbar's evidence, that it was not possible to deduce from the absence of GSR on the deceased person in clothing whether or not she had shot herself.
In what week of the trial was Mrs Dunbar giving her evidence? You know?
Well, I'll tell you.
I think it's a bit difficult for you to... I mean, the summing up is... The jury looked to the judge giving the summing up to stress to them the points that they need to take into account.
Well, I entirely accept that point. And just on the timing point,
yes.
Mrs Dunbar gave evidence on the 1st of October, and the summing up was started on the 25th and went through to the 31st of October. And it looked as though there were approximately sort of 7 or 8 days of evidence between the judge, her evidence, and the judge summing up to the jury.
Well, it seems that the prosecution forgot the clear import of Miss Dunbar's evidence. If the absence of GSR on the deceased's hands played such a significant role that it was summed up the way it was by the judge.
Well, the judge does remind the jury of Mrs Dunbar's evidence, and her evidence, just to remind the board, was that activities, lapse of time, deposit coming into contact with some form of fluid, they can all reduce even elevated levels of GSR to such an extent that there is an absence of GSR. That's her evidence at 336, lines 1 to 6. She was also recalled by the defence and cross-examined about the time that the deceased body was in the morgue, and her evidence was that she didn't conduct any GSR tests until a week after the incident. You have that at 445, line 20, and that moisture from the morgue could have also led to an absence of GSR. So the short point in my submission on this destruction complaint, so this is the lack of the ability to analyse for GSR, is that it offered no assistance in resolving the main issue for the jury, namely murder or suicide.
And when were the swabs taken of the deceased's hand then? Only in the morgue? Or... Of
the deceased's hand,
yes.
I'll check that, my lady. Of the appellant's hand, it was I believe the following day. Let me just check whether I can give a quick answer to that.
I'd rather assume they were taken at the scene.
I think your ladyship is right. I just want to... I think they were taken at the scene but not tested for a week. Yes, I think the I'm just looking at the, I think it's 248 through to 251, which is Superintendent Hibbert's evidence, was that he attended the property on the 5th of September, so on the day, and took GSR swabs from the hands of both the deceased and Mr Edwards. So, yes, your ladyship's right.
Mr Paul, the absence of GSR on the deceased's hands, I would accept it's not the most important strand in the prosecution case. The suicide note was, or Mr Major's evidence about it. But would you accept it's the second most important strand in the prosecution's case?
Well, look, if I can answer that by how it was presented by the prosecution, and rather how it. Just going back to the judge's list of circumstances, it features as number 4, and if that is the judge, effectively from her notes going through the Crown's closing, then it doesn't seem to feature as in the top 2. But so, my lord, I think that's the best I can do in answer to your lordship's question. Thank you. But I certainly agree with your lordship that it is the suicide.
I mean, circumstance number 1 was his gun was used, which, you know, that's not exactly favours one side or the other, is it? So there's only one gun to use.
Well, I think the fact that all of those circumstances are put in the way they are is that none of them are given priority to the others. No. And it is the suicide note that is the key to the prosecution case. The third delay complaint relates to the unavailability of Sergeant Brown. Now, the first point is a point Lady Rose made, which is we certainly from the evidence we don't know whether delay played any part in Sergeant Brown not attending trial. The only evidence as to why she was not available was that given by Superintendent Phipps, which was that she had emigrated and no longer was in Jamaica, and that's at 595. And there's no evidence as to when she left Jamaica. But in any event, the Court of Appeal dealt with her absence and the alleged prejudice at paragraph 70, 1935. And in my submission, it was plainly open to the Court of Appeal to find that her absence was no more detrimental than the absence of any other witness at trial. And in fact, I would go further and submit that the party disadvantaged by the absence of Sergeant Brown was the Crown, as it meant that the defence could focus on the alleged inconsistencies between her statement and the evidence of Superintendent Phipps without her being able to give an immediate answer to it. And in this regard, it is important to understand the two issues that her evidence went to. Her statement, which was not before the jury, but the board has it at, it's in supplemental bundle, I think page 2160, you have her statement. And her statement says that she observed a notebook and what appeared to be notes suggesting suicide. And that's at 2160. Superintendent Phipps's evidence was that Sergeant Brown had drawn his attention to the note, and he also said that the appellant had in turn drawn her attention to it, and that evidence is at 464 lines 1 to 6. The appellant's evidence was that he did not see the suicide note at the house, but heard Sergeant Brown say that there was a note. That's 1109 to 1110. Now, just on that point, there was other evidence as to whether the appellant was aware of the note, and that was given by Senior Superintendent Stewart. And his evidence was that he was shown the note in the appellant's presence at the scene. That's at page 89, lines 19 to 24. And it was put to him that he was effectively lying about that, and he denied that he was lying.
We have to keep in mind with all this evidence, it was 10 years after the event, and really nobody can improve on their statement about who was said what about a notebook 10 years later, is the truth of it.
My lord, that's right, and the judge as I'll go on to submit in a moment, gave in my submission adequate directions on delay affecting the memories of witnesses. You see that at least at two occasions in the summing up. But the point here is Superintendent Phipps was extensively cross-examined about the inconsistency in his evidence. He was questioned about not putting in his statement the fact that Sergeant Brown showed him the note in the presence of the appellant, which is at 597. He was questioned about Sergeant Brown's statement at 603. He was then questioned about not referring to finding the notebook when giving evidence at the preliminary inquiry at 615. And then, after a different line of questioning, defence counsel returns to the same questions at 680. And he was accused of lying and playing a game on several occasions. And just to give you the board the references, 607, line 9, 619, lines 1 to 2, 625, 635, lines 22 to 23, and 665, lines 20 to 21. And in the judge's summing up, she reminded the jury of this contradiction on more than one occasion. And so the jury understood that Superintendent Phipps's reliability and credibility were an issue for them to resolve. And it's just on the summing up, the references 1636, line 14, through to 1638, line 5. And then the judge returns to it again at 1657, line 23, to 1659, line 16. And in my submission, based on the cross-examination, the judge's directions on Superintendent Phipps, the jury would have been in no doubt as to the tasks that they were being asked to perform and the issues of fact that they were required to consider in deciding this point, whether the appellant pointing the note out to Sergeant Brown and whether this assisted in them deciding who had fired the shot that killed the deceased. In my submission, it is pure speculation to suggest that the inability to cross-examine Sergeant Brown prejudiced the appellant in this case. My lords, my lady, I see the time, and I'm afraid I'm not going to finish this first delay point this afternoon.
That's fine. Thank you very much, Mr. Poole. We will resume tomorrow morning. The board will now adjourn. Thank you.